Okay, I think we might be back. Maybe. I apologize. I'm going to give this a second. Okay, we're back. We're back. I don't know what happened other than the internet in this hotel went out. And I apologize for that. Let me just be sure we're live. If you can see me, please comment. And now we're on a different feed, so my apologies for that. But it looks like we're live. Okay, so we were talking about jury selection and how we need to get to 52. Well, we have 52 so far, and we need to get to 12 jurors plus 4 alternates. And we have, so far, as of today, we have 52 that are in the pool. So, okay, looks like we're back up and running. Phew, we're good. I'm sorry about that. That's like makes my heart drop when we cut out. So that's what happened with jury selection. You are now up to date. Now let's talk about the motions rulings. Several motions, as I mentioned. These were all filed recently. The judge hasn't had a chance to rule on them. Some of them, Lori Vallow Daybell filed from her jail cell. Others were, the prosecution responding. One of the things, we'll run through these. Lori asked that a question on the juror questionnaire be changed, that it include a bolded and underlined phrase that Lori Vallow Daybell denies these allegations. Well, the judge said, I'm sorry, the questionnaire already ran out. Your request is denied. There was an issue about Daniel Coons, a retired police officer from the Gilbert Police Department. He's been listed as a witness for some time as a police officer, and apparently within the past few months or weeks, the prosecution has changed him over to an expert witness, a firearms expert witness. And Lori Vallow believes because he's testifying as an expert rather than a police officer, that should not be allowed. The judge tabled that one. He didn't necessarily rule. It sounds like when this officer is called, Lori Vallow will be able to cross-examine him and ask him some questions about that. So that motion was tabled. Then we had the motion that Lori filed to exclude 3 of the state's witnesses, and the judge denied that. One of those witnesses was Kay Woodcock. Lori is making accusations that these 3 conspired with each other to talk about things. In fact, let me just play a little clip of what happened during that portion of the hearing today.
I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why let me just make sure I'm looking at the right one. The state's going to offer some sort of testimony from these 3 witnesses that are going to talk about, it'd go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about, none of them have personal knowledge of any kind of crime, so.
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood. She is a person who was present when the defendant was speaking about the victim being possessed, which goes to, again, the motive of this as well as the premeditation, and those statements were made months in advance of the actual murder. With regards to Nancy,
So that's going to be offered as some form of admission from the defendant.
so that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Christina Atwood.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay. And then
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations, again, of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
all right. Do you want to have further argument?
Just the fact that this information that is supposed to be coming forward is not. All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand, and then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this, and I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that, based on the state's avowal, that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that.
Okay, so denied for Lori Vallow Daybell. Kay and the other two will be taking the witness stand. Now, the other motion, and I hope this is the last time we'll talk about this, was to have me struck from the witness list. And I learned this morning around 8 o'clock that there was going to be this 1:30 hearing and that I may need to speak, but our attorney said he could speak. For those just getting up to speed on this, a few weeks ago, Lori Vallow filed a list of witnesses that she wanted to testify on behalf of the state, on behalf of the defense. That's problematic because as a witness, you're not allowed to be in the courtroom to hear other witnesses. It would stop me from reporting the news and basically put a gag order on me. Plus, I have nothing to testify about, nothing to witness. I filed a motion last week. We hired counsel here in Arizona to file a motion. He specializes in media law. He's done a lot of high-profile work. He represents the local media here. He filed a motion. and he showed up today to argue on our behalf. I realized as I was leaving for the courthouse this morning, I'm like, I should probably be in a tie, and ideally, I would have a jacket, a suit jacket, which I didn't bring with me. I meant to bring a tie and forgot. I forgot about a belt. I mentioned that this morning, and a kind viewer out there sent me a promo code to get a free belt. So thank you. And I was like 9 o'clock, and like clothing stores aren't open at 9. Macy's or Ross opens at 9:30. I learned. Anyway, I ran into Walmart, and thank you Walmart for the $10 tie. I will keep this tie forever. It's my good luck tie because the judge ruled in my behalf. I'm going to play a little bit of the back and forth about why Lori wanted me as a witness, which was interesting to hear, and the judge's response. I will be honest, I thought for a second there he might grant her motion either in part or in full. And I was a little worried because my colleague Nate Sunderland had to take the stand in a trial last December, just a few months ago. It was a civil trial between two businessmen, and our reporters' phone calls were subpoenaed, and one of them was played in court. And our managing editor, Nate, had to go to this trial and testify. He also was not allowed to be in the courtroom at all, except for that testimony. So I was a little worried, like, oh no, what if the judge does, throw her a bone and say, okay, Nate can testify, or Nate can be your witness. Anyway, here is how that played out this afternoon.
Is there a Mr. Eaton here appearing?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 122214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment, because you could impeach them with the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay?
We could just call him up from the back?
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
it's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it, and you're just taking her word for it like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Miss K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do
All
we
right.
know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So even though he's not a noticed witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Okay. I don't know if I should respond. I have not interviewed one person on the prosecution's witness list except Kay Woodcock. I don't know where Lori is saying that I've interviewed all these people. I just pulled up the list to double check. I have not interviewed one of those people. On her witness list, I have interviewed Summer and Adam Cox. Okay, I did interview Adam Cox. You're right. He is on the prosecution's list. That's it. Furthermore, there was 2 motions there. 1, strike me from the list, which happened, and then 2, she's alleging prosecutorial misconduct because she says Trina K gave me legal advice on or about March 11th. That's the day I went to Arizona. I did not speak with Miss K at all. The following week on the 18th, there was another hearing. Lori says that maybe Trina told me not to come because I might get served at that hearing with a subpoena. That's not true. I simply didn't go because I had other plans and had gone the week before and couldn't come back 2 weeks in a row. But on the 18th, after that hearing, I did email Miss Trina K and I said, Trina, I'd like to talk to you off the record about this subpoena issue, me being on the witness stand. Do you have a minute to talk? She called me a few hours later and we talked. She did an interview with me as she would with any other witness. She said, we will count this as our interview. What knowledge do you have of the case? And a couple of other things. I then said, I hope that the judge precludes the witness list or I might need to hire an attorney. And she specifically said, I can't give you legal advice. I cannot give you legal advice as the prosecutor, but if you're on that list, even if you don't get a subpoena, you can't come in the courtroom. That's when at East Idaho News, I worked with an attorney to prepare the notice that I filed. We hired legal counsel in Arizona, and I met and spoke with in person for the first time today, Trina Kay, in the hallway outside of the courtroom. That's it. So just to clear the record, that I was never given legal advice by the prosecutor. And also, I have never been contacted by Lori's defense team. I've told you before, I have spoken with Lori before all of this back and forth months ago. In fact, we were communicating daily. But I have not heard from her defense team. And I think they could find me if they needed me to. But also, I try not to give my opinion. Perhaps her defense team realizes that they should focus on other aspects of the case rather than trying to get me. Perhaps. Okay, that's it. That's all I want to talk about for that. So you can watch the whole hearing on our YouTube channel. But I mean, well, there's still more. Don't hang up yet. Don't turn off yet. There's still more, but I'm talking about me being as a witness. Some other motion rulings. So we talked about the juror question precluding me as a reporter, as a witness. I said as a reporter, I'm still a reporter, but I won't be a witness. The judge granted a motion by the prosecution to keep witness personal information private. For instance, if during the trial an email address is read out or a phone number or a social security number, we as the media need to block that and not get it out. Seems rational. Also preclude Lonnie Dworkin. This is Lori Vallow's expert who knows everything there is to know about cell phone data and gathering information and everything like that. Lori Vallow said that he hasn't had a chance to work on the case and we're in jury selection, and that he was going to send over some sort of motion tonight to say what he found, some irregularity or something. The judge said, sorry, he's off. We can't have him come in to try. He said, I already gave you a continuance to get that information in. I gave you more time. He didn't send it in. He's gone. So he will not be testifying. Lori's one and only expert will not be testifying. Precluding Lori's witnesses. This, by the way, when I say preclude, it means exclude. The legal system has to make things confusing, or I should say the English language has to make things confusing. The prosecution said that Lori filed her witness list way too late. And because of that, none of those witnesses should be allowed to testify. And not only that, the prosecution is having a heck of a time trying to reach these witnesses. Some of them, they can't to this day. And the defense admits they can't either. So if the prosecution deserves the right to interview any of the defense witnesses, much like the defense can talk to the other witnesses on their list. And here's a little bit of the back and forth over the witness issue. There was so much sound here I could have pulled, but let me just play some of it.
Everyone I've spoken with has not been.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dworkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side with the limitations at the incarcerated state where I am and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That
didn't-
negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother Alex Cox and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this, other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is, obviously, I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point. Then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit, just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information, because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest.
So I'm gonna stop there. There's so much more fiery stuff. You can go watch the whole thing on our YouTube channel when you have a minute. Remember, this is day 1 of jury selection. Normally, jury selection week is very slow. Like, you know, what are we going to talk about? Yeah, this juror made it through. This is not the case. And if this is a foreshadowing of the trial, we're going to have to make Courtroom Insider 3 hours every night because there's so much to talk about. So let me go real quickly. The rest of the motions that have been denied. Lonnie Dworkin was granted to get rid of him, not have him preclude Lori's witnesses. The judge is going to take it on a case-by-case basis. The prosecutorial misconduct was denied. And one other one, Lori has felonies that she's been convicted of in other states. The question was, do you let the jurors know? The judge said this will only become an issue if Lori decides to testify. And if that happens, then the judge will decide at that point if Lori decides to testify, if all of her felonies should be revealed or just 1 or 2. Because it can obviously, if a juror hears, holy smoke, she's been convicted of murder, her children, and her another woman, Tammy Daybell, that's an issue. It could change a juror's mind. That's everything that happened today in a 30-minute window. Let's get to Rachel Smith. This is a interview that I think you're really going to like. She gives us some insight into what to watch for at the trial. Remember, Rachel Smith has done over 100 or so homicide cases. She was a special prosecutor in Idaho in the Lori Vallow and Chad Daybell cases. She's done death penalty cases. She knows her stuff. And here is that interview. Let's take it away. All right. So Rachel Smith joining me now. Rachel, what questions do you hope are answered in this trial? Do you have any?
I think everybody's got a lot of questions that we would like to have answered.